private clients, to understand the basis of the case, you must understand the basic history. I know it's boring. I know we all thought legal history, Roman law, finished at law college. But to understand why these laws come, you must understand the history. Now, what is property and who actually, or when, other than the Roman law principles of property, the modern right of property that we know came from where? Did it come directly from the Roman law? Did it come through the Roman Dutch law? Or what is the English law that brought this basic principle of the right of property? Now, the English word property is derived from the Latin word proprius, right? This might be a bit boring, but please bear with me, right? Now, proprius means you own the property. If I have a property, I own the property. And I have the right to do whatever I want with the property. I have the right to alienate, I have the right to lease, I have the right to mortgage. That is my right, because I own it. As against what we learned at law college, you have common property, that is public, the beach, like I will got into things like that law college, but you have common property. Then you have property which is alienous, that is other people's property. Now, as far as my property is concerned, I can do whatever I want with my property. At the same time, I can't do anything with my property which will affect another person's property. Then you go into the sphere of public nuisance and private nuisance. But the fundamental principle that you must understand is, if it is my property, I can do whatever I want with the property. Unless by agreement with another party, I give certain rights to that other party. Right? So, the concept of the ownership of property is very individual to the person or the company, if it is a company. So, the basic principle that arises from that is what is called, and you would have heard, a man's home is his castle. Because my home is my castle. Nobody can come and walk into my home, or come and seize my property, or do anything with my property unless I say so. That is the first thing. The second thing is, I can only do something, or I can be forced to do something with my property only if there is a due process of law. Now, this all comes from the Magna Carta. Now, in 1215, it was King John at that time. He was with a nutcase, like most of our politicians, went on making laws, taxing everybody, and then the barons, there was an uprising, and the famous Magna Carta was signed in 1215. It came into operation later on. But the basic human rights that we know of now, and the UN Charter as well as the European Human Rights Charter, comes from the Magna Carta. Now, one of the main reasons about rising, or the barons rising up against the king, was that he says, okay, 5,000, whatever, let's say 500 pounds, you have to pay me. If you don't pay me, I am going to take your house. Right? So, one of the main concepts of what was enshrined is the right of every person to own and inherit property. Now, this is all going back to the person's inherent right of ownership of property. Right? Then, what specifically Chapter 39 of the Magna Carta says this: no free man shall be arrested or detained in prison or deprived of his freehold, that is property, or in any way molested, and will not send forth and we will not send forth against him, nor set against him, unless by the lawful judgment of his peers or by the law of the land. Right? The King George agreed that in the future he would not deprive free men of their lives, liberties, or properties unless it was required by existing and proper laws, and then only pursuant to fair and proper procedures. So, our law that we are practicing now in 2019 comes from the basic principles of the Magna Carta 800 years ago, or 803 years ago. So, why this is important is, these laws which have been going on for so long, the basic concept is this: I own my property. Even if I give up certain rights of myself, I can be acted against only and only by a lawful judgment of my peers. That means there has to be an executable judgment of court, or there has to be a law. Now, if you look at what Mr. Jayasundara speak about 4 of 1990, recovery of loans. Now, that was a law which was brought directly supplanting the Mortgage Act. Because the Mortgage Act, until then from 1949 to 1990, the Mortgage Act had specific provisions as to how a mortgagee, that is a bank, can recover money on a default on the mortgage. It's not a default on the outstanding amount or the financial relationship, the default on the mortgage. That distinction is also very, very important. Now, if you're a banker and your fundamental relationship with your customer, in the case of giving loan, will be you will be giving a loan to your customer under a loan agreement. Now, the loan agreement and what we can do under the Mortgage Act or what we can do under the Parate Act of 1990 is completely different. You can, on a breach of contract, you can sue a party on a breach of contract even if there is a mortgage, if you think that it is more suitable. But the right under the mortgage arises under a completely different system of law. It's not English law, it's not Roman law, it's the Roman Dutch law. The concept of mortgage in Sri Lanka comes from the Roman Dutch law. Now, that is because if you are talking about Parate, we speak to you about Parate. The original concept of Parate was a private agreement between two parties that if I default on the mortgage, you can sell it. Now, in Ramachandra HNB, Chief Justice Saraswati clearly said that is not our law. Our law is by agreement, you can't give one a Parate executory right. That is why 4 of 90 was brought in by law. Now, until then, no mortgagee or a bank could execute on a mortgage unless through Section 40, unless through the Mortgage Act, right? Now, that is a recognition of the basic principles in the Magna Carta. That either there has to be a judgment of a competent court, or there has to be a law which says you can do it, right? And that is what HNB versus Ramachandran versus HNB says, right? Now, the issue is what is happening now. Now, please don't kill me for saying this. The banks have had a very good run since 1990. Okay, so they had the Parate which they used, and we also helped, which they used. It's called a draconian. I don't think it's a draconian act, but it has been used and it has been abused. So the first hit was from Ramachandra saying no third party. Now that was sorted to a great extent sorted out by HNB versus Jayasundara, where they said that is I have a problem with that also, but besides that they have said okay, you can go for third party as long as the shareholders and the directors are the same or the beneficiaries, which is basically I don't agree with that judgment. Anyway, then the 5 million limit was brought in so that you can't go for Parate if it is less than 5 million. So the banks naturally are now constrained with regard to third party mortgages, which where you can't fix the veil of incorporation, go back to mortgage bond action. Right? Now, as far as Colombo is concerned, I don't know why the problem is, because if you go to the commercial high court, basically within 2-3 years you are done. God forbid if it goes to the Supreme Court, we are okay for another 7 years. But in the commercial high court, you are done for within 2-3 years. Even the district court of Colombo, it's pretty fast. Now, what has happened is that even that is not fast enough for some people. So they have now devised a way which I will come to, which they think is faster, but I think is a travesty of justice and an absolute mockery of the law. Now, I have been arguing this case, which I will first come to that, right? Like, okay, so what is the hypothetical action? If you have a mortgage, if you go back to the Magna Carta, then you come to the Mortgage Act. The Mortgage Act says, if you mortgage a property and there is money due on that mortgage, then you can go to court and enforce that mortgage and have a decree enforcing the rights of the mortgage. That is what basically the Mortgage Act says. Now in Ramachandra versus HMB, Justice Saraswati says that that concept, how you go to court for a hypothetical action is the refusal to perform an obligation. Is a cause of action in terms of Section 5 of the Civil Procedure Code. So if you undertake an obligation under a mortgage bond to pay on that mortgage bond, when you stop or when you neglect or you fail to pay on that mortgage bond, that is the refusal of an obligation, refusal of a performance of an obligation. That means you come within the definition of one of the limits of Section 5 of the Civil Procedure Code. So that is, it's not the Mortgage Act. The Mortgage Act says you do it as a hypothetical action, that's all. But the right arises and the cause of action is refusal of an obligation. Okay? It is not, if you are going under the Mortgage Act, it is not the breach of the underlying loan agreement. It is a breach of the mortgage. Right? So that distinction is very important because the Mortgage Act restricts the relief for the mortgagee to very, very specific media on which you can enforce it. If you can't enforce it that way, you're lost. Right? So it's very, very important to understand that if there is a mortgage in respect of a property, your action on that, any failure to perform an obligation is restricted, I believe personally, to the provisions of the Mortgage Act. Right? So, this is again from Ramachandra. It says it takes on the concept of Roman law of hypotheca, whereby a real security is created over property, with the mortgagor remaining the owner in possession of the property, and provides a specific remedy to obtain an order from court declaring the mortgage property to be bound executable for the money due and for a judicial sale of the property. So the money is not due under your underlying loan agreement. The money is due under the mortgage. That is why it's very important if you have a mortgage for the bank, the people in the bank, it's very important that unless you demand a mortgage, you have no cause of action. A letter of demand has to be sent in terms of the mortgage, not your underlying contract. Because your cause of action arises when you are pay up on the mortgage, you don't pay, you come under Section 5 of the Civil Procedure Code. Right. This is more of the same idea. Okay? Right. Now what has happened? Since of late, is not all, but some banks and some councils, for whatever purposes, have started this thing of, even if there is a mortgage in existence, they go to the district court in terms of the Debt Recovery Act. Right? Now, I personally believe, and I think there is a fair amount of people, lawyers, who believe that that is an absolute travesty and a violation of the concept of the Mortgage Act as well as the Debt Recovery Act. Now, why do I say it? I say it for good reason. That is the matter Chandaka said I am arguing in the Supreme Court. What does the Mortgage Act say? Section 46 of the Mortgage Act says what? It says you can't, if you are executing a mortgage, if you are enforcing a mortgage, if you are executing a mortgage, you can only recover money from the mortgage property. You can't go against anybody. Unless, in terms of the amendment in the 1990s, you have a section 47A declaration that you are entitled to, that the mortgagor says, you are not restricted to section 46, you can go against my property. Okay? So that is clear, because that is an agreement between private parties. Right? I say, I am mortgaging this property to you. Right? And the bank says, okay, for that mortgage I am giving you the money. If you don't pay me in terms of the mortgage, I am coming behind your property. But section 46 says you can go behind his property, but you can go only against the property that has been mortgaged. Why is that? That is what is called financial management. So if I have one property, I can focus that property to a particular loan. I have another property, I will focus it against another bank and another loan. And whatever point you can actually pick, okay, I let this, and it happens. I let this property go, but I am very concerned about the other property. So that is management of your finances, which every individual, and management of your assets that every individual has the right to do. Right? That is the protection that is given by section 46. That is, if I mortgage my property to a bank, I am assured that that bank will come and only take that property in respect of that mortgage. If I want more money, I can go to another bank with another property. Right? So that is why section 46, the genus of section 46 is that. Right? Now, with the revolutions of 1990, with regard to the banking, they said no, the mortgagor can, by declaration, the notary has to explain it to him, give up that right. Okay? Now, it's couched in a way that the borrower actually has a choice. As of now, if you're mortgaging, you have no choice. With your mortgage bond, you have your section 47A declaration. Right? Now, what section 47 says is, 46 restricts your right to go against only this property, but I don't mind. I am giving you the right. If you can't recover everything from this property, you can go against my other property. That is what section 47A says. Section 47A does not give the mortgagee a right to go against any property. If you look at section 47A, which I will discuss, it specifically says you can go against the other properties only after you finish recovering whatever you can from the mortgage property. Okay, it becomes important because of the problem with this debt recovery, this conduct, whatever the actions they are doing in respect to the debt recovery act. Now, if that is the, so if that is the underlying principle of law on which mortgages work, can you use another media to obtain the same redress? That is, can you, where there are specific provisions in the Mortgage Act, where rights are given, protections are given, can you, even with the existence of that right, can you go by some other way which is not strictly a recovery of mortgage, right? So what has been done, I don't know who has told these people to do it. I don't know where the thought came from. I have a basic idea where it came from and who brought it up. But basically, the idea is give the entire mortgage act, throw it to a side, and go by one word in the Debt Recovery Act, and that is underlined. Several words are underlined, but right. So what it said that this is how the Debt Recovery Act is being brought into operation. It says, now look at the wording and think of what I said earlier, right? Debt means the sum of money which is ascertained or capable of being ascertained, capable of being ascertained at the time of the institution of the action, and which is in default, whether the same be secured or not. Now this whether the same be secured or not is the pivotal point that is being argued, right? Or owed by any person or person, jointly or severally, or as principal, borrower, guarantor, or in any other capacity, and alleged by a lending institution. This is the important one, right? By a lending institution to have arisen from a transaction in the course of banking, lending, financial or other allied business activity of that institution, but does not include a sum of money owed under a promise or agreement which is not in writing. So unwritten agreements are out. I think it's 150 or something with threshold, that is out. So what does it say? This is the Debt Recovery Act is there within the definition itself. What is being enforced is the debt. Right? It is the debt. That is why whether the same is secured or not comes into operation. The argument is you are enforcing the debt. You are enforcing the debt under the loan agreement, not under the mortgage. If you are enforcing the debt under the loan agreement, then you can go again in terms of the Debt Recovery Act. That is the argument. Right? The problem is not in the Debt Recovery Act, because the Debt Recovery Act was specifically made for the bank or the licensed institution. Right? Now, the problem arises in terms of section 46. Right? So, the law with regard of the Mortgage Act. Right? Section 46 of the Mortgage Act, in full I will read it. No decree in any hypothetical action upon any mortgage of land which is created after the coming into force of this section, and no decree in any action for the recovery of any monies due upon any such mortgage shall order any property whatsoever other than the mortgage property to be sold for the recovery of any money found to be due under the mortgage. That is the distinction. The distinction is, even if there is an underlying commercial contract or a banking contract, you can't enforce that underlying contract if there is a mortgage. You have to enforce the mortgage. That comes with the proviso. In this section, action for the recovery of monies due upon a mortgage includes any action for the recovery of any debt secured by a mortgage, whether the cause of action sued upon arises by reason of the mortgage or otherwise. So, the debt that these guys are saying in terms of the definition gives them the right to come under the Debt Recovery Act is specifically taken out in the Mortgage Act. Because the Mortgage Act specifically says recovery of a debt where a mortgage has been given to secure it means an action under the mortgage bond. And if the action is under the mortgage bond, in terms of section 46, you have to enforce a decree obtained in that action against what? The mortgage property. Okay? Now, section 6 of the Debt Recovery Act says, when you file action under, this is the reason they are doing it, right? When you file action under the Debt Recovery Act, you go on the basis of basic organized right, and the defender has to come and show, get leave to defend the action. Okay. Now, what is the discussion that is being given to court at that time? What it says is the court shall, upon the filing by the defendant on an application for leave to appear and show cause supported by the affidavit, grant leave to appear and show cause against the decree nisi either. So, the granting of leave comes naturally. I don't think any judge can refuse granting leave to appear and defend subject to these conditions. One, upon the defendant paying into court the sum mentioned in the decree nisi. That is the full outstanding amount. Number two, upon the defendant furnishing such security as to the court may appear reasonably and sufficient for satisfying the sum. Normally it's 1/3, half the court's gave. Then upon the court being satisfied on the contents of the affidavit file that they disclose a defense which is prima facie sustainable and on such terms as to security, framing and recording of issues or otherwise as the court thinks fit. So what happens here? Now, the law as we know under the mortgage bond secures a loan which arises out of a mortgage bond by enforcing the mortgage. Right? What happens here? The plaintiff, in addition to the mortgage, is getting further security. Right? In most instances, courts order 50% of the claim as security. Now that is in direct, so at the end of the case, if the defendant loses, the first option is what, where is the recovery going to come from? The security you have given to court. That is in direct violation of section 46. Because even if you say 47, you can go against other property. Section 47 specifically says you can go against the other properties only if you can't satisfy your decree from the mortgage property. So it has to be first you have to go against the mortgage property. If you can't recover the full decree from the mortgage property, you go against the other property. What is being happening now is you first go against the security that has been provided. If that is not sufficient, you go against the mortgage property. It's completely against what it says. Right? So that is the first reason, because they get at least 50% security before they start the trial. And knowing most of the borrowers and customers, they are not going to put 50%, they will negotiate and settle the case at that time. Okay? Or they will not have time to give the 50%, they will forget about the case, and that is the end of the. Now, the issue is this: even if there is no security given by the defendant, to proceed against the mortgage property, you still have to file a hypothecary action, because the hypothecary action is, as I stated earlier, means an action to obtain an order declaring the mortgage property to be bound and executable for the payment of the monies due upon the mortgage and to enforce such payment by a judicial sale of the mortgage property. So even if your security is not enough, you can't go against the mortgage property unless you have a hypothecary action. Now, I think it's pretty clear, but I don't know on what basis these guys who are doing this are going to finally enforce it. Because if you have a decree of the absolute in a DR action, you can't anyway go and enforce it against the mortgage property. Because to enforce it in the mortgage property, there must be a declaration of court enforcing that mortgage to be executable against that property. Maybe these plaintiffs are happy with 50%. Or maybe these plaintiffs are happy if you get the order absolute, thank you very much, your auditor is out of your back and your NPS will be okay because it's done, there's a decree, it goes to the other file, so then your NPS are okay. That might be the reason. If it is recovery of the money, I can't possibly see a way of doing this. Okay? And I have said this to several of my clients and I have lost whole load of cases. They said, we'll go to a lawyer who can actually do this. I said, then you go. Okay, right. Now, one other reason is one other violation of this basic right of justice that everybody is entitled to and protected by law, and there is supposed to be rule of law in this country, which you don't know. But you see, in terms of the Debt Recovery Act, if you go for hypothetical action, we have all done hypothetical action. It's a pain because you have to do this, show that, the original document, security file is not there, security file is in Maharashtra. This is the person who signed is not there, the Sahikare is not there. It's a pain. Right? That is right. Because if you do it under Debt Recovery Act, it's summary procedure. Summary procedure means affidavit, reading your objection. The tipo, I think it says read your objection. And if I'm not mistaken, then commenting, or then the plaintiff comments on the objection, written submission, done and dusted. Now, can you do that for a mortgage property? Because it's that person's right that you are interfering with. Right? So, you come, because this is the draconian nature of using a quite harmless act and completely perverting it. So, then you get, we all have done hypothetical action, MB action. We all know how long it's going to take. We all know how difficult it is. We all know the defenses that these guys keep on taking, saying, Hassan Karene, Hassan Karmega Jackena, Kiyuvena, English in Tibet, Sinhala in Tibet, Tamil in Tibet. Those are the, nobody actually takes any defense anymore. Right? So that is the stand. But even the defense that one guy says, I didn't sign it, the trial takes 2 years. Right? But if you do a DR action, how long does it take? 6 months, 7 months, you are done. That is why you are doing it. But can you, my personal view is that it's wrong, can you use this procedure and get your decree, then try and go and enforce it without a mortgage decree in terms of the Mortgage Act? Okay? Right. One other reason is the concept of interest over capital. Now, right. Now, Section 5 doesn't apply to the civil law ordinance, to the banks. Finance companies, you can't apply. So, there is a difference. But in terms of Section 21 of the Debt Recovery Act, you can obtain interest over 100% of your loan amount. Right? So, double the interest you can get if you come under the Debt Recovery Act. But if you do it under the Mortgage Act, if I'm not quite certain, but unless you're a licensed commercial bank, you can't obtain more than 100% of your interest from your capital. Okay? Because this says, notwithstanding anything to the contrary in this act or any other law, an institution may recover as interest in an action instituted under this act a sum of money in excess of the sum of money calculated as principal in such action. But if you don't come within the Section 5 of the Civil Law Ordinance, you have to come through the DR Act to get your 5%, to get your 100%. So, we took it up in 2 cases, in the district court, but it got things fixed. They said you took the money, pay the money. If civil appellate, they also said took the money, pay the money. Now it's in the Supreme Court, right? Now, my situation is this. There was, of course, another argument is that the Mortgage Act is a general act, the Debt Recovery Act is a special act. The special act will apply over the general act. Therefore, you go back to that debt which is secured or not, and therefore the special act will apply. That is how the civil appellate decided on the basis that the Debt Recovery Act is a special act, and therefore it overrides Section 47 and 48. So let's see what happens in the Supreme Court. I have not much hope in that, but then let's see how it goes. But basic premise, if you actually go back to the basics of the law and not just read one act in isolation and say, because this has the word secured or not, that will permit me to enforce a debt arising out of in relation to which a mortgage act has been entered. I respectfully say you are treading on very thin water, because somewhere down the line some judge is going to say, where are you going to enforce it? Because in terms of section 47, you will not be able to enforce a decree from arising out of a debt recovery action on a mortgage property, which has to be enforced in terms of 46 and 47 against the mortgage property first. If you can't recover from the mortgage property, then you can go anywhere else. Okay, so hopefully that, especially what now these things have been going on for some time, so there is no point talking about what is the debt recovery act and what is summary procedure. I'm just keeping these with you. Just look at it. My paper that has been given, because there are some miscommunication. The first part is with regard to Parata execution, but Mr. Dian will be dealing with it. You can read it, you can throw it if you want. But this part, keep in mind, because this is going to come up very soon somewhere and going to bite us all. Okay, thank you very much.